So a lawsuit is now trying to force the Supreme Court to immediately review New York's defiance of the New York State Rifle and Pistol Association versus Bruen decision. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our right to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they are huge Second Amendment supporters. I love their coffee, but also I love how they support the Second Amendment cause by having dedicated roasts for GOA and FPC, which if you purchase those, it will actually donate to those organizations. So I highly recommend you check them out. I will leave a link to Blackout Coffee down in the details section and the comment section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we will be discussing how a challenge to New York's concealed carry law is currently being distributed to the Supreme Court for their consideration. Right now, the plaintiffs in this lawsuit are trying to force the Supreme Court to review this case right here and now. In this case, the plaintiffs are asking for the court to bypass the lower courts, to bypass review by those lower courts, and instead to review New York's Concealed Carry Improvement Act right here and now on their own. This case that we're going to be discussing is called Gazzola v. Hockel. This Gazzola case focuses on the impact that the CCIA will specifically have on dealers and gun stores within the state of New York. These businesses argue that the CCIA is unconstitutional because it violates the Second Amendment and also that Bruen decision. They argue that this New York law has severe impacts on gun stores and gun dealers, which are a critical component to the right to keep and bear arms, and that the CCIA essentially tries to regulate these types of stores out of existence within the state of New York. Here, the gun stores are challenging how the CCIA has an ammunition background check requirement, how it restricts the types of sales that they can do, and also it challenges a reporting requirement that the state put in place through the CCIA. The gun stores here, the plaintiffs here are arguing that the CCIA forces stores to have to assist the state of New York in creating a firearms registry, which is actually prohibited under federal law. In this case, the plaintiffs originally sought to obtain a temporary restraining order and also a preliminary injunction from a district court. However, the district court, in reviewing the case, rapidly denied the TRO and also the preliminary injunction. The court issued the denial without even holding a hearing on either the TRO or the preliminary injunction. The plaintiffs then submitted an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that the denial of the TRO and also the preliminary injunction without a hearing, they sought for the Second Circuit to find that that was an error. However, the three-judge panel at the Second Circuit level originally denied that interlocutory appeal, denied that type of finding, and they ultimately found that the district court below was correct. In response to that denial, the plaintiffs then submitted a petition for writ of certiorari before judgment up to the Supreme Court. This is an interesting mechanism to seek early Supreme Court review of a case before a judgment of the lower court is even issued. This type of petition invokes the Supreme Court's statutory power to grant review of a case before a lower court even steps in and issues a judgment. Under Supreme Court Rule 11, the Supreme Court can, anytime before judgment, deviate from the normal appellate practice to review matters of such imperative public importance as to justify immediate determination in this court. And that is what the plaintiffs in Gazzola are seeking. They want to bypass the lower courts, bypass the Second Circuit, bypass the district court, and instead have the Supreme Court rule on this issue right here and now. In this petition, the plaintiffs argue that this case is the organic progression of the trilogy of Heller, McDonald, and Bruen. The FFL in the lawful stream of commerce in firearms is inextricably interwoven with the fundamental individual rights. In response to that petition, the state of New York submitted their opposition to the Supreme Court, and they said that the Supreme Court should instead not grant review of this case. New York states in response that petitioners seek to halt the implementation of the enforcement of these measures by the New York State Police and the State Division of Criminal Justice Services, principally claiming that some of the laws violate the Second Amendment and others are preempted by federal law. The district court denied petitioners' motion for a preliminary injunction, and an appeal from the division is now pending before the Second Circuit. The Second Circuit heard arguments in this case on March 20th, 2023. Petitioners have failed to show any reason why this court should take the extraordinary step of bypassing the Court of Appeals review and granting certiorari before judgment. Indeed, petitioners have not presented any pressing issue for the court to review even in the ordinary course, nor have the applicants pointed to any split in authority on the issue they raise. To the contrary, this court in Heller expressly stated that nothing in its opinion should be taken to cast doubt on laws imposing conditions and qualifications on the commercial sale of arms. Moreover, this case's interlocutory posture renders the resolution of any issue premature. New York's primary argument is essentially that this case and issue are premature at this time, and that the Supreme Court should instead let the Second Circuit decide those cases, decide this issue before they decide to step in. Recently, the Second Circuit, like the state of New York mentioned, heard oral arguments on 5 cases which challenged the state of New York's new CCIA law. One of those cases was in fact Gazzola. We're currently waiting to see how the Second Circuit will rule in all those cases, including Gazzola. And essentially what the state of New York is arguing and saying to the Supreme Court is that the Supreme Court should hold off until we get that decision by the Second Circuit. Now, after New York made those arguments, the plaintiffs in Gazzola decided to waive their right to file an opposition in the case and instead requested that the Supreme Court waive that ability of the plaintiffs and instead that the Supreme Court should distribute the case immediately up for their consideration. And that's exactly what the Supreme Court did. The Supreme Court has now set the Gazzola case for a conference date, which is April 21st. This means that next Friday, the Supreme Court will get together and decide whether or not they want to grant review of this case before judgment. Typically, we find out whether or not the Supreme Court decided to grant review the following week. The following Monday, we get an order list by the Supreme Court, and it will say whether or not cert is granted to cases, and also it will say what type of cert was denied in a variety of cases. And just keep in mind that most cases are in fact denied review. Ultimately, I think the Supreme Court will agree with the state of New York and will decide to deny review of this case and wait for the Second Circuit to issue their decision. Then we will have to wait to see what the Second Circuit actually says in their decisions, what they decide to do with the 5 CCIA cases, and depending on how the Second Circuit rules and what they say in their analysis of those 5 cases, then I think at that time there is a higher likelihood that the Supreme Court will get involved with all those issues. Remember that in the Antioch case, which is one of those 5 cases, the plaintiffs also sought for emergency review of that case. They sought for the Supreme Court to step in an emergency basis. However, the Supreme Court denied review. They denied emergency review. But in the order of denial, Justice Alito wrote in that order that the Second Circuit must essentially do the right thing, that they must review all 5 of these cases, issue their decisions, and then at that time, if the Second Circuit doesn't do the right thing, then the plaintiffs in Antioch could seek Supreme Court review and could try to seek emergency review once again. So I think that's much more likely of what's going to happen. I think that's the route that these cases are going to go down. We're going to get a Second Circuit decision on all 5 of these cases. The Supreme Court is not going to step in until then, and really it's going to be based on what the Second Circuit says in those 5 cases on whether or not the Supreme Court at that time will decide to step in. But I wanted to bring this to everyone's attention and bring this onto your radar because right now a case is distributed to the Supreme Court for conference next Friday, and we will wait to see whether or not the Supreme Court will grant review of that. My guess, again, is that they won't, but there's always a chance, so I just wanted to bring this to your attention. But if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.